it's possible we won't today, but as I say, we're going to make every effort to do that. So with that, let's get started. I wanted to mention too, at the front end, I won't make you look at me the entire time. How about that? Okay. I wanted to mention at the front end too, sort of what the Attorney General's limited role, if you will, is under FOIA, okay? So in my part of the presentation, I'm going to be dealing with records, okay? And my co-worker, Assistant AG Ray Pierce, is going to be addressing meetings, okay? So if you have meetings questions that you know you want to ask, please hold off on those until Ray's portion of the program. But we thought it was sort of important at the front end to just quickly remind you, or maybe you don't know, what the AG's limited role is. I'm going to be going over records, as I said. Very important exemption under FOIA for public employee-related records that I'll be hitting pretty hard. And the Attorney General does have a specific role under the statute, under FOIA, regarding those records. But even as to those records, the AG is not a compliance office. We don't enforce FOIA. We don't have anything to do with that. So this is really being hosted by General Rutledge as a public service, because she very much believes in the importance of being educated about FOIA, the importance of transparency, but also the understanding of that there are exemptions out of the law that are important as well. But we don't counsel anyone on FOIA in the public sector other than perhaps the agencies that the Attorney General's office represents, but that's in a different capacity, of course, than what Ray and I are going to be doing this morning. We're sort of the educators here. You know, it's not binding on anybody what we're saying, and it doesn't have the force of law. You probably know there are a couple of ways to enforce FOIA. If those of you out there may be on the end of wanting to make a FOIA request and you feel as though you're not being heard, there are procedures for that. So all of that was just a big way of saying that, you know, we're not your counsel out there for those of you with FOIA issues. We're happy and we enjoy doing these PowerPoint educational, and we're a resource for you in that regard. But obviously your local counsel at the local level, if you get in trouble, that's the person who's going to be representing you, and they're the ones that need to be trained up on FOIA. And if they haven't, you know, be sitting in our webinars as well. So that caveat, let's get started about records. And unlike meetings, which again, Ray is going to be addressing, there is this big definition of what a public record is under FOIA that's in the Act itself. And if you haven't already, and Ray will be plugging it too, the FOIA handbook, which the Press Association publishes and we review and edit, has the actual text of FOIA at the front of it. And we have a lot of those handbooks available. The current one is also available on our website. This breaks down, what I've done here is broken down the three main parts of this definition. And you can see it really doesn't matter what form, what format, that's the technical term, the record is in. It could be a video, audio, electronic record, hard copy record. It has to be kept. Hopefully you realize there's no requirement that a record be created in response to a FOIA request. FOIA is a request for records that are in existence at the time the FOIA request is submitted, and that meet this test of a public record and that are not exempt. So this whole presentation is based upon a three-part sort of test, if you will, or three-step process. First step is the entity covered by the FOIA. Well, we're assuming today that it is. For the most part, those are going to be governmental entities, and they're going to be subject to FOIA. Their records are potentially going to be, that they keep, are potentially going to be public records under the Act. I'm in the second part, which is what you're looking at a public record? Does it meet this definition? Third part, I'll get to it a little bit, is there an exemption? Don't get ahead of yourself, okay? Don't be talking or thinking about exemptions unless and until you first decided that what you have that would be responsive to the records request meets this definition. So it has to be kept. This is the most important part of the definition, that it constitutes a record of the performance or lack of performance of official functions. That is an exact quote from the Act. So this is the main takeaway I want you to have from my hour, a little bit plus, talking about public records this morning, this definition and this part of the definition. So how does that work? Well, if it's a record that's kept, there is just a presumption that it is a public record. If during the workday, in the office records, this thing is maintained by that public office, there's a presumption. But it's rebuttable, okay? It's not a hard and fast presumption. The important part is you still look at the content of their record to determine whether it does what, whether it reflects the performance or lack of performance of official functions. So you have to look at each record. You don't create a record, but you look at the records that you have based on your understanding of the FOIA request. Is this a public record? You know, the presumption is that it is. But at the end of the day, based on the content, the presumption may not hold. In other words, so this is sort of an evidentiary rule, if you will, okay? And we know this from this Pulaski County case. Here's an important note, and a lot of people, I think, may not really realize this, and it doesn't come up often because most records are really kept at the situs or the location where the entity that's subject to the Act is, okay? So if it's a request for a police department's record, city police department, those records for the most part are going to be at the city police department or at City Hall, okay, if they're city records. But where the record is maintained, where it's kept, does not matter for purposes of that public records definition. Remember, this is the part that matters. Does it reflect the performance or lack of performance? It has to be kept within the scope of employment, but it doesn't matter where it's located. It might meet that definition if it's sitting, in this case, in this Fox versus Peroni, believe it or not, it was a check at a bank, sitting in a bank account. And I won't go into the details of this case, but just trust me when I say the locus, the location of the record is only important to determine whether it falls under the presumption, okay? So in other words, if the record isn't at City Hall for some reason, let's say the mayor took it home for some reason and it's in a file at his house for the time being. Maybe he was working on it and there's no copy, but a FOIA request comes in, and for whatever reason, it's still located at the mayor's home. Does it matter? Well, the presumption that it's a public record probably doesn't apply, right? But the test is not based on the presumption, okay? The test is this part of the test. And let's assume that record that's sitting at the mayor's office is a record of the performance or lack of performance of official functions. So what is the mayor supposed to do? Take that record back to City Hall and have whoever is handling the records request, have it at that point, okay? So that's just an example, but the importance, don't be thinking that because it's offloaded somehow in some other location that matters for purpose of that definition. Okay, so having said all that, I'm gonna quick, wake up moment for those of you already snoozing out there. What about emails that discuss personal matters? True, false. Those just are not public records. If it discusses personal matters, you can just know based on that information. That's enough by itself to let you know that's not a public record. That's that true or false. Hopefully you said false, okay? Because first off, what do we know from the records definition? You've got to look at what? The content, okay? So you've got to look at the content. And the mere fact that it has some discussion of a personal matter may not be determinative at the end of the day. Well, what's the test? How does that work? Well, we have a very recent case we had this substantial nexus test up until fairly recently, and that terminology really doesn't even appear in the most recent case decision. It's all about whether the personal and the public business, so private matters, public matters, are the messages that so interrelated and inextricably, it's a tough word, intertwined. Okay, so in other words, are the personal communications and the public business communications, they're so interrelated, you can't really separate them. That was the case in Pulaski County, according to this recent Arkansas Supreme Court case. If you read both of these cases, the eggheads out there who really want to know how this works and what the court thinks, read this Myers case, very, very recent case, came down in December. And this is what you're looking for. And in this case, the circuit court said, yeah, these are just all public records based on this nexus test. We can't separate out the personal from the private. The Myers court said, oh, yes, you can. They are separate at different times, emails. They're not all intertwined. You've got to go through them separately and decide. And that apparently is still ongoing. It's called an in-camera review. Has to go back to the circuit judge to do that again. And that happened in the Pulaski County case too, by the way, a couple times. It went back to the trial court judge. So it's time consuming, it's tough, but that's just the way the definition and the test works. So hopefully with that was really quick and dirty on what is a public record. And I'm going to go in now to some mechanics about FOIA requests and handling them and like that. But before I do that, I just want you to remember the fact that something is a public record doesn't necessarily mean it's going to be made public. So it's a little confusing and a little bit of misnomer. We haven't gotten to that third step yet. Does an exemption apply? Every custodian, and we'll talk about who that is in a little bit, has to also consider exemptions, possible exemptions, because they are mandatory. If a public record is exempt under a specific exemption, it cannot be provided. There's no discretion to provide that record. So we use the terminology non-exempt public record, because just saying something's a public record, again, doesn't mean it's necessarily going to be made public. The question is, or the real way to word it to my mind is it's a non-exempt public record. Okay, with that, let's get into, as I said, some of the mechanics about FOIA requests. Most of this is from, or much of this is from the perspective of the public entity handling the request. These webinars, obviously, hopefully we've got some citizens out there too, concerned citizens, interested citizens wanting to make FOIA requests. But I think many of our attendees are in the public sector, and they're trying to understand how FOIA works so that they're knowledgeable about that. So it's geared a little bit more that way, just because of we know who, for the most part, tends to be our listeners on these webinars. So there is a citizen requirement, Arkansas citizen requirement under FOIA. You should know that. No public entity violates FOIA by providing a non-exempt public record to a non-Arkansas citizen. Okay, let's say that first off. That's not mandatory, okay? You're not prohibited, in other words, from giving records that an Arkansas citizen would get to a non-citizen, but you're not required to do so. And I will tell you, because we get lots of FOIA requests in this office, we pretty routinely, diplomatically and politely turn people back when we know they are not an Arkansas citizen. Now, there is no set test for that under FOIA. I will tell you, that's more of a practical question based on the information that was given to you with the request. Can you tell in the face of it whether they're an Arkansas citizen? Is it Arkansas? Maybe it's an email address, maybe it's a business address, maybe it's an Arkansas area code phone number. We probably would go ahead and take those. We don't always reach out to the person and say, hey, prove to us you're an Arkansas citizen. But on occasion, we've had to do that. And, we suggest maybe you give us a local address, a business address. There are lots of ways, I suppose, you could do that. I think I've heard maybe of one city maybe required maybe a utility bill, as evidence that they lived in Arkansas. So, you want to work with people. We're not about road blocking, but on the other hand, that's what the act is about. It's Arkansas citizens. That can include corporations doing business in the state. Okay. So just want to emphasize that. But again, not a violation so long as you're giving out records that are open under FOIA. Are there any responsive public records? We've been over that definition. So that's the second step in handling FOIA requests. Who's the custodian? Okay, the custodian under FOIA is the person with administrative control of the public records, the records of that office. Okay, that's all FOIA says. So on an agency by agency, office by office basis, you have to, basically, you should appoint someone, assign someone the custodian role. In our office, it's our chief deputy, okay? She's the chief lawyer under the Attorney General Rutledge in our office, chief deputy, Julie Benefield. She is the official custodian of our records. All FOIA requests are responded to by her, and everything goes through her before records go out, okay? So that's just by way of saying you should have a centralized place. You don't want people to be running around wondering where to submit their FOIA request. And in fact, if you get a record request and your office is not the custodian, but you have reason to know who is the custodian, then you're supposed to direct the person to that place. So don't get, just at the front end, we think best practices obviously is to do what we've done, have a centralized place where FOIA requests are submitted, and then that person is the one to be attending this webinar and to get even better training through perhaps your local council and that sort of thing. Had a question on that citizen requirement in the chat feature here, and can it be circumvented if you hire an Arkansas attorney? I would not consider that circumventing the act. It really does not matter how that attorney, who that hired that attorney or how they were engaged. If the request comes in from an Arkansas citizen, that's all that matters. So whether that person really even cares about the request and whether they're doing it, on behalf of someone else is really irrelevant. You're not supposed to be thinking or considering really who that person is or the purpose of their request. All you're supposed to be considering is, are they an Arkansas citizen? And then get on with it. Is what they're wanting, does it fall under the act? Are there responsive public records? And then let's get into that. So not an Arkansas citizen at first, but they go to find someone to make the request on their behalf, someone from Arkansas. I think they're good to go. Requests must be sufficiently specific, okay? I put that in quotations there, PowerPoint. That is straight from the law itself. So if you truly do not know what's requested, okay, it's so wide-ranging and sometimes maybe unintelligible, or you just don't know what records to even start sorting through or a way to do your search because you really don't know what they're requesting. You can cite this language back to the requester. Maybe they'll narrow their request, okay? But this is very request specific. I really can't give you, an example other than maybe someone from our office wants, let's say, all expense records for the Office of Attorney General during Attorney General Rutledge's, now almost 8 years in office. Okay. Is that sufficiently specific for us to locate those records with reasonable effort? No. I mean, that would range from everything to the rent that this office pays out of her O&M for our office space, to travel records, to just in other words, all your expenses. office, records of all your expenses during your time in office.
Attorneys do a lot of traveling.
Yeah. So that's just really impossible for us to really locate those records with reasonable effort. Okay. The burdensome, too broad, oh, it's too burdensome, that is not a basis to deny a request. So sometimes this can be seen like a subtle distinction, but usually when you see the actual records request, you can tell the difference. Is this sufficiently specific, or do we know what they want? But boy, there are just a ton of records here. We know what they want, and we can get them with reasonable effort. That's not a big deal. We can locate the records with reasonable effort, but it's going to take a lot of, it's reasonable effort. It's still going to be time consuming, and there are a bunch of records. It's really burdensome on our agency. That is not a sufficient basis. Okay. In that case, usually you've got to work with the requester and maybe get them to agree that the usual turnaround time for a FOIA request usually is 3 working days is what we think the law really contemplates most of the time. But with some requests, that can't really be done. Okay, it's just impossible to do it in 3 working days. And we've heard of situations, sort of word of mouth, of getting requesters to agree to, okay, we're going to work on this, devote X amount of time per week to your request, and we'll do a download, for certain intervals. And you might have success that way. So I have this screen up here just because I know, particularly with electronic records, emails, request for email seems to be the latest and greatest area that people are seeking records. Oftentimes there are a lot of responsive records, but usually we think you've got to work with the most requesters on those records. So I've kind of gotten ahead of myself here on who the custodian was. I think I've already talked to you about this. Administrative control. Private entity, this kind of goes to, remember I said it doesn't matter where the record's located. The definition of a public record has nothing to do really with where it's located. That only goes to that presumption. So in my mayor example, the public official has to produce it, okay? And it's a burden. The burden is on, in that case, that city to acquire the records, go out and get the records if whoever has the records is refusing to turn them over. I've mentioned this 3 working days, unless it's an active use or storage. Most records, in all likelihood, are in active use or storage. And so for the most part, if you receive a records request, let's say on a Monday, we don't count that first day. So Tuesday, Wednesday, Thursday, and we usually probably close a business Thursday is a safe bet. That's when the records must be provided, okay? But there may be some occasion, some rare occasion, where those records are just sitting there and they're available immediately. That would be pretty unusual, but it is contemplated by the Act that could occur. So here's the process here. What about making copies? Can you charge for that? Only for your actual cost. There's no set fee under FOIA. You have to look at your actual costs. And in our office, it's a very, very small cost because there are economies of scale, I guess. But we actually, a number of years back, figured out what our copy machine costs were and really reduced it to a per page cost that we could prove up if someone thought we were overcharging. And we have to be prepared, which is what the Act contemplates. Down here, this last bullet point, itemizing the charges, that is what FOIA contemplates, okay? Now, if you anticipate it's going to cost more than $25 to make those copies, you can make the copy charges, you can insist that they pay the entire amount up front. So let's say it's going to be $50 that they're going to be billed. Don't make those copies. Let them know first off. I heard of one occasion years ago, it was going to be about $400, and the clerk, it was a municipal clerk, I think, city clerk, went ahead and made the records and then called the person. The person said, oh, well, I don't want them. Well, she'd already gone to the trouble to make those copies, And at that point, they just had to eat that cost because there was no obligation on that person to get them at that point, just having made the request. There's no obligation for that person to follow through. So get that charge up front if you estimate it's going to be more than $25. And hopefully you realize you cannot charge for your employees' time. Now, there is this new law that law enforcement out there hopefully is aware of. If you're not, you need to become aware of it and get familiar with it about your audio and video recordings, okay? And there is some authority now for charging for time spent producing that. That's a new act. Okay, so remember at the beginning I talked about the three-step process. Is the entity subject to the act? Is the record subject to the act? Is it a public record? Now we're in the exemption. So we're assuming for this portion of the PowerPoint that what you're looking at, that you've pulled in response to that FOIA request, meets that test of being a public record. Just a refresher here, you have it, it's kept, you didn't have to create it, it exists, and it reflects the performance or lack of performance of official functions, okay? Lock that in. Next step, it goes out unless what? Unless some exemption applies. Okay, so before I get into these specific couple of exemptions I want to flesh out that I think a lot of you out there may be most interested in. Records exemptions under FOIA. FOIA is a starting place. There are a number of records exemptions in the Act itself. I'm looking at the current handbook, and we now have, I should have this memorized, but I don't, so bear with me. We now have 26 exemptions, specific exemptions under FOIA itself. But FOIA says, except as otherwise provided by this law or some other law, otherwise, records are open. So except as provided by FOIA or some other law. What that means is there may be exemptions outside of FOIA that apply to those records. Okay, if you read today's paper dealing with the Duggar case, there was a ruling just recently came down from the Arkansas Supreme Court, and that part of what that was about was a records exemption dealing with victims of a sexual related offense, sex offense. And there is a specific exemption for sex crime victims, okay, outside of FOIA. So I just mentioned that because this is a big law to begin with that custodians have to be aware of, but depending upon the particular area of government that you deal with, that you administer, you probably have to be aware of some other exemptions. Now, who would be most aware of those exemptions? Probably the Department of Human Services, right? Because they handle, in that case, it was juveniles that were what's called in need of supervision, okay? They were at risk. And so DHS did, a home study and all like that. So, and that's a specific set of records exemptions dealing with DHS law. Okay, you probably know there are also specific exemptions dealing with records of juvenile proceedings. Okay, so we don't have time, obviously. At the back of the handbook, there is a laundry list. It's not exhaustive, but it's fairly extensive list of exemptions outside of FOIA that you might just want to peruse. And maybe some area you work in, maybe one of those exemptions, comes into play on occasion. I don't know. But today, for the most part, we'll just be focusing on a couple of exemptions dealing with employee-related records. I will mention the ongoing law enforcement investigation exemption because I know there are quite a few law enforcement folks out there, and you, I'm sure, are aware of that exemption. And the only thing I'll mention about that exemption, which we occasionally have to sort of remind people of, is just because there's an ongoing investigation doesn't mean that every record that is a part of that investigation is exempt. Now, don't freak out. I don't want to blow your mind there, but you have to also be mindful of the fact that it has to be sufficiently investigative to be exempt under the law enforcement investigation exemption. And we know that from one key Arkansas Supreme Court case. And you probably know that your standard, like arrest records, okay, for the most part, are not exempt under FOIA. The court in that case specifically addressed that, as well as, I think, like booking information at the jail. And so those records are actually part of an ongoing investigation, but based on a narrow reading of exemptions, which is what is required under FOIA. FOIA is liberally construed in favor of openness. Exemptions are narrowly construed. So if there's any doubt about whether an exemption applies, well, what's going to happen? The court is going to err on the side of openness. If you get hauled into court on it, the person making the request is sitting out there and is being told this is exempt, and you don't think it is, you think it's ambiguous or there's some uncertainty, you probably have some comfort that you may prevail at the end of the day, because exemptions are narrowly construed. And that's where the ongoing law enforcement investigation, sufficiently investigative records comes into play. I needed to mention that in passing. I don't believe I have a separate screen on a PowerPoint on that. If any of you out there in law enforcement really want more information about that, there are a number of AG opinions you can find on our website. It's a fairly friendly search engine that walks you through how to do a search for previous AG opinions, and there are a number on that particular exemption. So let's get into a little bit of detail here about these particular kinds of records. So there's a record called under FOIA an exemption for something called an evaluation record. And then there's exemption for something called a personnel record. Completely separate. And as public employees, we have certain rights with respect to these kinds of records. So you should be interested and know about these as they pertain to you personally. Hopefully none of our records will ever be FOIA'd, so to speak. That's the colloquial way, FOIA submit, were you subject to it? Have you been FOIA'd? But if you are, these exemptions can come into play as to records that pertain to you. So what's an evaluation record? Well, it's first off, very important part of the definition. It has to be created by or at the behest of, at the instigation of the employer to evaluate you, okay? So standard evaluation records, routine, obviously, but these may come along during the year where a supervisor comments on your performance, on your job performance. And that may well meet this definition of an evaluation record. Well, what does that mean? So if someone asks for a copy of your evaluation records, an Arkansas citizen, what records do they get? Well, if something meets this definition of being an evaluation record, the very first requirement that must be met in order for that record to go out is that you must have been suspended or fired, suspended or terminated based upon that evaluation. If you were reprimanded, anything short of suspension or termination, and it may be a positive evaluation record. You see there, no one would have ever been suspended or fired based on a positive evaluation record. So those records don't go out. Doesn't matter that they're good. Good evaluation records don't go out to an Arkansas citizen. You get your own and you can turn them over, but an Arkansas citizen wouldn't get your good ones. And a bad evaluation, you were suspended or terminated, then you go through the rest of this test, okay? Finally, there has to be a compelling public interest in disclosure. And there's sort of a test that we kind of been developed by some commentators on FOIA over the years to kind of determine that. But the most important thing is here, unless it's created at the behest of, by your employer, or instigated by the employer, So internal investigation records, okay? There's been a complaint and then there's an investigation into that complaint by the employing entity. Those records created in the course of the investigation, many of them are going to be evaluation records, okay? So then you go through this test. If as a consequence of the complaint and ensuing investigation, the employee is not suspended or terminated, those investigation records are exempt. The ones that constitute evaluation records are exempt. Here's that test for compelling public interest. Your position and in the agency is very important. Most important would be the nature of the infraction, okay? It's kind of how strong is the public interest in knowing why this person was suspended or terminated. Okay, I need to keep moving. There's a lot of information on that screen, but just know there is a test for that, factors to consider, and this is where the custodian of public records needs to be trained up on this information for sure, okay? Second kind of record relating to public employees, personnel records. Very different from evaluation records, and entirely different, not a subset of each other. What is that? It has to pertain to the individual employee and not be an evaluation record. So it wasn't created by or at the behest of the employer to evaluate you, but it really relates to your individual employment circumstances, okay? Usual example I give would be like your sick leave and your annual leave, your vacation records, leave records. Those are to be open unless what? Unless releasing them would be a clearly unwarranted invasion of your personal privacy. And this requires a balancing of interests. Note there that FOIA very clearly contemplates the release of some of our records that we might kind of think are private, okay? And the example I often give is our salary information. I mean, I may not tell my neighbor what my salary is, but at the end of the day, when an Arkansas citizen requests the salaries of public employees, this balancing test is going to weigh in favor of the Arkansas citizen, the public's interest in that. Why? Because they employ us, okay? And it has to be, in order to exempt that information, not provide it, what does it have to be? It's a high bar. It has to be not only an invasion, it has to be an unwarranted, it has to be a clearly unwarranted invasion of your personal privacy for a personnel record to be exempt. Most personnel records go out under this test. Just know that, okay? Because it's a high bar for exemption. Many evaluation records don't go out. Why? Because most public employees keep their jobs. Most public employees are never suspended or terminated. And so their evaluation records are exempt. That protects the evaluation process. That's the idea behind it. If you get kind of not the most stellar evaluation in the world, but it's not so bad that you're ever suspended, but it's like, you could really improve in these areas. The idea is to let you improve and go forward and not have a bunch of public scrutiny on that process, and let your supervisor be very candid in their evaluation of you. Personnel records, on the other hand, the balancing test is very much in favor of openness, but it has to be a record that really relates to you and your employment situation specifically. Now, there's a lot of information even under this balancing test, or maybe a separate exemption, that does not go out, okay? So this is a laundry list of commonly exempted, stuff that, information that should never be released. And we use the term redaction, should be removed from that public record before it goes out. So security numbers, medical information. There's a separate specific exemption for medical records, but even medical information that might be in your personnel records. Like, for instance, I applied for leave because I'm having, heart surgery in a month, So the amount of time you requested for leave, the amount of leave that was approved would go out under that balancing test, okay? But why you needed to be on sick leave, I think I said annual sick leave, that would be redacted. That medical information would not be provided, nor would the rest of this kind of information. This, you probably know, is a very specific separate exemption under FOIA. So you don't have to do the balancing test for this information. This is a separate exemption personnel record. Personal contact information of non-elected public employees is exempt. So that should always be removed from any personnel record before a personnel record is released. We think date of birth, these are based on identity theft concerns. Any information about your personal life, we think that balancing test, again, going back and forth with screens, that would be a clearly important invasion of personal privacy. How many children you are, whether you're divorced, how many times, if you've been married, who your spouse is, none of that information we don't think would merit a overriding public interest. Your privacy interest would prevail. On the other hand, this information is commonly open. Most typically, this is going to go out. I think probably most people would agree that this would not be surprising to them, except maybe your resume, your employment applications. And employment applications often include resumes, obviously, and letters of recommendation, okay? So if you're in the public sector and you're applying for another job in the public, or you're in the private sector and you're applying for a public sector job, you should just be on notice that that's probably going to be an open book. It's going to be difficult, if not impossible, for you to keep secret the fact that you're looking for public employment. And then once you've applied, whether you're the successful or the unsuccessful applicant, most of this information is going to go out. So that's just for awareness. This is some more detail that many of you out there, unless you're on the front line handling records request, really don't probably need to have this locked in as much as certainly the person who is an actual custodian of records or the one who's expected to be assisting the custodian of records needs to know about the possibility that these personnel and evaluation records can get intertwined, if you will. They can get mixed in, and typically the scenario is that internal investigation that I mentioned, where there's maybe a complaint or for whatever reason, someone's job performance is being investigated and people are being interviewed maybe about a certain incident, or maybe they're just over time, some issue has arisen and someone becomes the subject of maybe a grievance. And so there's the agency looks into it. Okay. As you can see, you sometimes even have more than one person involved in that as the subject of that investigation. So that's when we get into mixed records. There are a number of AG opinions that we've issued again on this because the Attorney General has a specific obligation under FOIA to issue official public opinions. They're non-binding, but she is required by law to review the custodian's decision about these kinds of records we're talking about now, about evaluation records and personnel records. So if you search the term mixed records in our database search field in looking for an AG opinion on our website, you won't find just a ton of opinions, but you'll find some if you want to get further educated about that. This is more for awareness. It's not so simple sometimes as saying, oh, well, this is this person's evaluation record and they were never suspended or terminated, so it doesn't go out. There may be part of that record that's an evaluation record of someone else involved in that incident who was suspended. Okay, and so it can be tricky. You have to classify each record and apply the test. That's the main thing, okay? And sometimes a record that must be disclosed about one employee can't be disclosed about another. So what do you do in that case? Sometimes you just redact the other employee's name. That's maybe sometimes all you can do, okay? So this is a lot of information about mixed records. Most of this is for awareness, to know that it can get complicated, it can get messy, usually in the internal investigation context, that hopefully none of you out there will ever be the subject of. But if you are and there are records requests, these kind of rules can come into play. Now, when you're dealing with these types of specific records, there are very clear notice requirements and timelines that are different from the what I call a standard FOIA request. So once that custodian knows that this person is wanting personnel or evaluation records, and I will tell you, and this is true of our office as well, when we get requests for these kinds of records, usually the person asks for the personnel file of that individual employee or former employee. Former employee, those are still personnel or evaluation records of that person if the office still has them. Just because they are a former employee doesn't mean those records, they might not be still responsive to a FOIA request. This is a very specific 24-hour period notice, okay? Very short timeline. That's why I keep emphasizing having a custodian of records. If you're a big agency, having other people in supportive roles for the custodian to be trained up on FOIA, because you have to decide what within 24 hours when you get a request for these kinds of records. You have to tell the employee about the decision. Now, obviously, you don't tell the requester or give the requester anything yet, okay? You tell the requester your process in the request, and you'll provide the records within the required time frame, which is usually, as I mentioned earlier, we talked about 3 working days. But you have to make your decision. That's the bottom line here. The agency has to decide within 24 hours what they're going to do with that records request, but only for these specific kinds of records, and tell the employee. If it's a former employee, actual notice is not necessary, okay? It's overnight mail if your other notice fails. So usually this is the case with former employees. You may only have a forwarding address. You may not even have a current forwarding address. You just may have the address when they worked for you. And that's all you can try to do is send overnight mail to that. Otherwise, personal notes, phone call, maybe email would suffice to your employee, letting them know there's been a request for your records. This is the decision of the custodian. And then when they're armed with that decision, they can come to the AG's office. The requester, once they get the records, or if they don't get the records and they don't like that, they can come to the Attorney General. But what are we doing out of my office? We are reviewing the custodian's decision. So this decision has to happen, and you can understand why that is, because boots on the ground, the AG doesn't know what was going on in that circumstance or surrounding that employee. And there's, oftentimes, at the end of the day, not much the Attorney General can say because it can be very fact specific to the local, what was going on locally. But nevertheless, this is a process that's available. And we have to respond to those within 3 working days as well. I think I mentioned this early. Employees get their own records, okay? So if the record is maintained about me, it's a record that is either my evaluation record, my personnel record, and it's kept. Doesn't matter whether or not it would be open to an Arkansas citizen. I get to see my own records, okay? That's the way FOIA works as far as that goes. So I had a question here. I think hopefully I answered that question about what if notification isn't made within the 24 hours. So I think I mentioned that actual notice is not required. So if it's a current employee, and the way we handle ours, I would make every effort within that 24 hours to actually personally contact the employee. I wouldn't rely upon leaving a voice message, probably, okay? But if you've left several voice messages and you've tried to reach this person, they're not on sick leave, you've looked, through your records, you don't know why they aren't responding to you, but you've made every effort within that 24 hours to leave them messages then that's probably the best you can do. Okay. That overnight mail is basically when you don't have contact information to where you could personally notify them. Okay. Maybe you have a phone number for a former employee and you've left a message there. If to be, totally careful, you might go ahead and send them the overnight mail in that circumstance. So again, actual notice not required, but read up on that part of the notice provision of the 24 hours. Here's another question. Personnel requests include background checks. Now, when you say background checks, just because we occasionally are aware of certainly the criminal background checks that are conducted through state police. Okay. And that's done through, ACIC, the Crime Information and Center. And so I think that's what that's ACIC, right? Yeah. But if you're talking background checks, meaning you've contacted former employers for maybe to verify a reference like that, and you document it, that if you're talking about that kind of background check, then let's go through the test. How does it work? We've been talking about this for the last hour. We're assuming, again, that it's an entity subject to the act. So it's probably a governmental body we're talking about, a governmental entity. So let's say this is a state agency person asking this question. Or you're submitting your request to a state agency. State agency, first off, they've got to look at their records. They might be responsive. And this person wants all personnel records of this employee. So you go in, and maybe you do go in their HR file. That's our starting point to look for personnel records, the HR file, where you're going to have your employment application and all like that. And maybe you've got their resume, and maybe you have their references, and or maybe it doesn't matter where records are kept. Don't get me wrong. Elsewhere in the agency, these records may be maintained somewhere else. But somewhere, I gather from your question, that there is a background check. That is, there's a record that shows that you contacted a reference that was given on their job application to verify that they actually worked there, and to what kind of job did they do, and maybe you make notes and you kept that record. Is that a public record? Well, let's go back. What's a public record? Record that's kept. We've already said it's kept. I hope I'm not giving you a headache here, sorry. Does that reflect the performance or lack of performance of official functions? Hopefully you realize yes, because it was part of whoever did that background check. They were trying to consider whether to hire that person that applied for that public sector job. So that was part of what they're supposed to do in the course of performing their public duty and their public employment, was do that background check. So yes, my immediate response would be, that is a public record. What's the next step? Is it exempt? Does some exemption apply? Probably not, but without seeing the actual record, it'd be hard to say. Maybe for some weird reason, the person's a current public employee, let's say they're asking for a promotion, and they give some previous reference contact, and for some reason in the notations their phone number, their personal phone number appears of your current employee. Remember, that's a specific exemption. I only give that by way of example. Be careful. Just once you determine it's a public record, you still have to, well, is there anything exempt in here? Now, based on this question, I doubt there's going to be any exempt information, but you can't know until what? Until you look at the record. Every records request under FOIA requires, the response requires eyeballing actual records. That's just the way the act works. And you could potentially get in a lot of trouble and get on the wrong side of the law, and the result by not doing your content-based review, because that's what the Arkansas Supreme Court has held twice now is required. What about criminal? Now, I think all of that information is exempt, but again, this is a good example of an exemption that is not in FOIA itself, but I use the term bootstrap, or like, you throw out somebody else I used to work for would have an example of throwing out a fishing rod and fishing elsewhere for, can we catch another exemption in some other statute? Well, it has to be specific. It has to be specific where it's clear that this record, which is a public record, nevertheless, it's exempt under FOIA. And other exemptions are supposed to mention FOIA, other statutes. But I believe that adult and child maltreatment records, which I think I actually began with at the beginning of my talk, I mentioned a very recent federal decision, 8th Circuit. I may have mistakenly said, no, I don't think I said it was a state case. It was a federal case. And it dealt with child maltreatment records, which were exempt, but they had, the agency, the local entity, had failed to redact the information, and that's what the case was all about. And at the end of the day, they were not held accountable for that because it was determined not to have been, intentional. But Ray, who is going to pick up here shortly on meetings, will be talking at the end of his presentation about enforcing FOIA. And I said at the beginning of my part, the AG is not an enforcer of FOIA. We're not a compliance office. We can't force anyone's hand. We can't counsel as your attorney. Then we really get in trouble because the Attorney General is specifically prohibited from engaging in the private practice of law. So she can't sit down with an individual and be their individual lawyer, okay? She's the lawyer for the state generally, and for Arkansas citizens as a group, but not individuals personally providing legal advice. So we have to be careful about that, and also we don't mislead people. But as a practical matter, most importantly, you don't want us counseling you on these things because we won't be your lawyer. Those of you out there who are in the public, are in public jobs, when you're having to deal with FOIA issues and you're concerned that you really don't understand how the law works and you've got a records request and this Arkansas citizen is intent on getting these records and they are going to pursue every means possible to get the records, you want someone locally sort of holding your hand, if you will, and walking you through that. And doing any further, training and follow-up perhaps in the specific areas that you administer. Because the most important thing is you be knowledgeable about those areas and the kinds of records, that you handle. Okay, that's the most critical thing. So with that, I am going to briefly move this and turn it over to Ray Pierce for the meetings portion.
And now for something completely different. I'm Ray Pierce. I'm Assistant Attorney General in the Office of Attorney General Leslie Rutledge. Nobody wants to see me. Let's get this little device and make it work. Beth, you need to scoot out of the shot because it wants to focus on you.
Okay.
Okay, that's good enough. It's supposed to autofocus and it's supposed to, know where the person is, and it's not working, so I don't care. You know, it's just not
turn my video off.
It's just not that important. Want to remind everyone that people have been doing a good job about this so far, but if you want to submit any questions, go through our little chat feature here, that bar at the bottom center of your screen, and go to the little speech bubble chat icon, and be sure to direct your questions to all panelists so everybody on our end can read your questions. And remember that if you're watching us on Facebook or Twitter, to please use our hashtag. It's hashtag FOIA. So it's hashtag FOIA. Okay. Now we're going to talk about, I think, we're going to talk about meetings, I'll say that. No, there we go. Jolly good.
I didn't mention phone. I was supposed to address that. Phone recordings. Remember they submitted that question.
Oh, yeah, we did. Well,
Shall we do that?
come on over.
Okay.
We have a little brief timeout from meetings because we have to address a question that came in a little bit earlier having to do with telephone recordings. So we'll just go ahead and do that now.
So Beth is back, and I'm sorry I neglected. I forgot to do that. We did get a question. I think it was local law enforcement, perhaps. I think maybe a sheriff's department has had a FOIA request for phone recordings for a certain number of days. Okay, and the question was basically, is that subject to FOIA? I think was the question. Hopefully, you're now armed with some sufficient information to get the gist of what that's going to require. That kind of request is going to require. I walked through. Obviously, Sheriff's Department is subject to FOIA. The first and most important question there is going to be whether those phone recordings constitute a public record. Do they meet that definition of a public record? And so remember the definition, doesn't matter the format in which the record is kept. It can be audio, video, electronic. So you've got phone recordings that have been kept. So that's going to meet that part of the definition. Does it reflect the performance or lack of performance of official functions? Okay, what are you going to have to do there? Probably somebody's going to have to go through and listen to the recordings for that period of time, which will be somewhat burdensome. But remember what I said, that is not a basis standing alone to decline a FOIA request. And the time frame there was probably such that my gut sense is you're going to have to deal with that as a legitimate FOIA request, and someone go through those recordings. And if we could kind of compare and analogize, if you will, briefly to what I said about emails, remember what the test is of what reflects the performance or lack of performance, because it's quite possible with a recording of every phone call into a public office, you might have records that a recording or some information in a phone call that doesn't meet that definition of reflects the performance or lack of performance of official functions. What's an example? Well, it would be maybe an employee calling in to leave a message for their spouse, or leaving a non-employee calling in, or calling in to say something about that's going on in their personal life. So bottom line is it's a content-based test, as I emphasized before. And so going through those recordings will be necessary. Now, it may well be at the end of the day that that the entirety of those recordings are a non-exempt public record. But you can't ignore, first off, the definition of a public record, and then does an exemption apply? Because it was a sheriff's office, I mean, maybe it was a tip. Maybe somebody called in with a tip on
an offense or someone who's currently under investigation, maybe it becomes part of a criminal investigation. And I think that would probably be sufficiently investigative in nature if it was information from a potential witness about a potential crime that's being investigated, then maybe that portion of those recordings. I'm just trying to, I don't know if any of that is in there, but give you a sense of what will be involved. And at the end of the day, I really encourage you to get with your local counsel on that one to decide how best to handle it. But that public records portion of the discussion is what you'll need to delve into. Okay, thanks. Hope that was helpful.
I'm sure it was. Okay, now back to meetings. All right. With the one thing I'll say about the FOIA portion of meetings is that section of the law, section 106, is a whole lot shorter than the records portion, which is good in one way, but also can be a little frustrating in other ways because it doesn't define very much, and with the meetings aspect, and you'll hear me say this later on in the presentation, but it really boils down to the do right rule. Just knowing what is expected of public officials, members of governing bodies, and doing the right thing. So with meetings, we go back to that three-part analysis. Step one, is the entity covered by the FOIA? Well, yes, it's going to be if it's, if the open meetings portion is going to apply, then it's going to be a governing body of a public entity. So he's like, why? Yes, it is. So we move on to the second step. Just like with records, is the record covered? Well, step two here is the meeting covered? All right, now what is a meeting? And this is the part that just frustrates me to no end. A meeting, it's a very circular definition. The tautology is great with this one. A meeting is defined as all meetings, formal or informal, special or regular, of the governing bodies of all municipalities, counties, boards, commissions, and school districts. I kind of cut some of the things out of there, but it's municipalities, counties, and school districts, all boards, bureaus, commissions, organizations of the state of Arkansas, supported wholly or in part by public funds or expending public funds. Those mean all meetings, formal or informal, of those governing bodies shall be public meetings. So, in other words, under this definition, all meetings of governing bodies are meetings. Which leads us back to what is a meeting? And we're going to go into that in a little bit of detail, kind of some, I won't say, exceptions, but, odd scenarios, whether that is considered a meeting or not. And then the question of what is a governing body? That's the body that can make decisions. All those governing bodies, municipalities, counties, school districts, boards, bureaus, commissions, organizations of the state, supported wholly or in part by public funds or expending public funds. So, if you've got public funds wrapped up in this, and that body can make decisions on how to spend those public funds, then yeah, that's likely going to be a a governing body. So meetings is, meeting is a meeting where the governing body meets and the governing body makes decisions. Well, how many members does it take to make a meeting? Let's say you've got I'm going to use city councils just because that's kind of what I'm familiar with, and it tends to roll off my tongue easier. So you got a 7-member city council. How many members, does it require to have a meeting under the FOIA? Well, FOIA does not require that there be a quorum, so you don't have to have, as many as 4, 5 if it's a 9-person council. It doesn't have to be a quorum of the governing body's members to be there, to be involved for a meeting to be found. And that's that El Dorado Broadcasting case from way back in 1976. So it doesn't have to be, the entire board or even a quorum of the board, because remember, a meeting is all meetings, formal or informal. So, you can have an informal meeting where public business is being discussed, or issues that are being discussed that are likely to come before the board for resolution. If you've got less than a quorum, but they're meeting and they're discussing business that's likely to come before the council for resolution, then a court's likely going to see that as a meeting. So is there any particular number that is there a threshold beneath which a meeting is not being found? Well, yes, more than one. One is that floor. Because if you've got one person who's discussing public business and, on it, with himself and making decisions on all this sort of thing, well, then, you probably need to look into that person. So yes, at least 2. If you have at least 2 members of the council that is discussing public business or business likely to come before the council for resolution, then yeah, a meeting can be found in that case. Which means you really shouldn't be doing that. And a lot of times they do. It's rather unfortunate, but they do. Well, what about if members of city council, quorum, what have you, are, if they find themselves together at the same social meeting, social gathering, say a mutual friend is having a dinner party and they both happen to be there, and they start, just kind of talking about city business. Is that a meeting? Well, this office has opined that, maybe not in that case, especially if the social gathering is incidental and intermittent. If it was just serendipity that they happen to both be there at the same time, then probably not. If it is not so coincidental or intermittent, then maybe they keep showing up at the same social gatherings on a fairly regular basis and slip off together to discuss business that really should be discussed in public. Then, a court may be more likely to find that that an improper meeting has taken place. So again, as with so much in the FOIA, and this is something that you just need to hammer this home into your brain, write it in stone. So much in the FOIA is fact-based. So it really is going to depend on all of the attendant facts and circumstances. Just like with records, you have to go through each record and read each record to know what's in it so that you can make that decision on, is this record exempt, or is portions of this record exempt, or is it not, and it just needs to go out. Same thing with meetings. Is this a meeting? Well, we have to look at all of the attendant facts. Was this just incidental or intermittent? Was it just like I said, serendipity that they just happened to be there? Or is this more of a routine thing that one might be able to make the argument that it's planned, or, some sort of furtive decision to get together to discuss business that really ought to be discussed in open meetings. So it's very fact-based, and so you really need to keep your eyes out for that. All right, for all the attorneys here, let's say, if you're on a city council or you're on a governing body of some sort, and you get together at the annual meeting in June, and you just happen to run into each other and start talking about, city business. The court, we've said that that's likely not going to be a meeting if, the governing body didn't have any control over that conference, or they didn't have any control over sending you there. If you're an attorney, you're typically going to go to the annual meeting to get all your CLE hours of the year, except for your 2 hours here, so that's good. If the governing body really doesn't have any control over that, then probably not going to be considered a meeting. But again, the do right rule. If you run into other people in a non-business situation, you just need to leave those kinds of conversations, just need to leave them by the side of the road until it's time to discuss them in public, because that's where the discussion is supposed to be at. So, yeah, probably not a meeting at social gatherings if it's incidental and intermittent. Probably not a meeting at a conference if the governing body didn't have any control over that conference, or sending you to it or something, or anything like that. So, all right, let's talk about virtual or e-meetings. Very much like what we're doing right now. All right, a question has come in asking, about an Arkansas business that does business with the state, and what is the threshold that a business's meetings are subject to the open meetings portion of the FOIA. In that case, there's typical internal meetings generally aren't going to apply. Aren't going to be subject to the open meetings portion. If what you're talking about is, how the business is going to perform its contract. Let's say it has a $1 million contract, and it has, it's sort of latitude on what it does, but not necessarily any latitude on how much is spent, because the contract is for X amount to produce, some commodities or such and such a service. But the internal meetings on how you're going to provide the service probably is not going to be subject to the FOIA. Now, if it has latitude on how much public money it's going to spend, then then we get back to that definition of if it's supported wholly or in part by public funds. So if this business is supported expending public funds and you've got some discretion on how you spend those funds, then you might have a situation where a court could say, yeah, those kind of meetings ought to be open. But again, it's going to be very fact specific and the typical situation that I'm aware of where a business is contracted to provide a specific service, how they go about providing that specific service typically is not going to be, in the public realm. If the contract says, just give us this service, so. Please address social media interaction between elected or appointed officials. We're going to get there. So, virtual meetings. We're all very experienced with virtual meetings over the past couple of years. Virtual meeting is a meeting of a governing body that is held when the governing body is discussing public business, but doing so in a way where the members are not all gathered together at one place. So we think, old-fashionedly, think teleconferences, telephone conference call, or, in the present day, thinking of WebEx or Zoom meetings, things of that nature. So here's what the basic rule is. And this 1985 case in Rehab Hospital Service Corp kind of set the standard. Is in that case it was a telephone conference and it was all and they had to have what the court said is the public had the right to be able to hear or otherwise monitor the call. So that right had to be safeguarded. And the way they did it was with the use of of a speaker. You remember back in the days of landlines, for those of you old enough to remember this, the days of landlines, you would have a conference call and then there would be just like a speaker that all the calls would be broadcast out of. And that's the kind of thing they were talking about in the rehab hospitals case. But the point is that, yes, you can have those kinds of remote distance virtual meetings as long as it's still done in public. That the public has a way to listen or otherwise monitor the telephone call or the computer conference. And a lot of governing bodies, a lot of public entities, have learned how to do that over the past couple of years, having city council meetings or whatnot via Zoom. So there, you would just give out, the internet link and how you log in or login information, or put it up on, live stream it on YouTube or some other streaming service so that people can listen in and know what's being said, even though they're not there in person and the rest of the board aren't there in person, but the public still has a right to hear. So just having a virtual meeting and everybody's spread out everywhere is not some sort of an exemption to having we can't have a public meeting because we can't have the public here together, so I guess we'll just meet and talk about all this stuff in private. No, it doesn't work that way. One thing you can't let them do, and I'm speaking as a former newspaper reporter, thing you don't want to let them do. And a lot of city councils or quorum courts or other boards or commissions, they will still try this. They will still try things like polling. So, where you get, the mayor or one city council member to talk to individual members individually and see how they're going to vote on a matter, taking a poll. You up or down, you up or down. Having secret telephone conference calls, and otherwise secret meetings, and those are absolutely verboten. They're not allowed. And yes, there are still governing bodies out there that try to do sneaky things. And the story I always I like to tell back when I was a reporter is there was a city council that I would cover periodically, little small town. And I got word that the city council had a practice of meeting at a local diner every Monday morning, and they just sit around, kind of like a Stammtisch. They just sit around a table and have breakfast, and they might be yucking it up and swapping stories and that sort of thing, and also maybe talking about city business at the same time. And I finally went down and I confronted them about that. I busted them in the act and had to inform them tactfully, diplomatically, but had to inform them that no, they couldn't do that. I mean, they could have their little Monday morning roundtable, their little Stammtisch, but they couldn't talk about city council business that they're going to be talking about later on that evening. But that was against the FOIA. And that sort of took them aback. They just never considered that. What do you mean we can't talk about it? We're all friends and we're just here at the diner. And I said, no, that's not the way it works. So, yeah, they are out there, and they will try to do sneaky things. So you can't let them, not even once. So you got your governing body members, and then you got the idea of openness and discussing public business in private. It can be very tempting. Don't do it. And if you're a city attorney, county attorney, or whatever, don't let them do it. Just stop. Hi, I'm with the press. I see you're having a meeting. Gee, it would be awfully a shame if I had to report that you were having meetings that were violating the FOIA. Anyway, and if you're on a governing body, note well, any action that taken at a meeting that was held in violation of the FOIA is void ab initio. It is as if it never happened. And this can have serious ramifications. So let's just say that, for instance, city council is having a little Monday morning roundtable at the local diner, and they decide amongst themselves that they're going to hire person X to be the next police chief. They've got, X, Y, and Z who have applied to be a police chief. They've all kind of decided that, yeah, we want person X without discussing it in public, without voting for it in public. And they're just going to come back and say, hey, at the meeting later that night, and just to let everybody know, we've decided to hire person X as the police chief. And somebody says, wait a minute, but I know there were 3 people that applied for it, and there wasn't any discussion. How can you just say that you've hired person X to be the police chief? Well, that decision, person X can show up the next day, show up for work, but he's not the police chief, because that decision that was taken in secret and then just sort of announced in public is void. So it can have serious ramifications. So don't let them do it. And, Judge, not kidding. Judges, judge, be serious. This was a clip from Democrat Gazette, back in December, where the Parla City Council had tried to, as you can see there, thwarted the intent of the open records law at every turn and the open meetings law. They had tried to, the Parla water system was getting ready to put, Central Arkansas Water was appointed as receiver for this little town's water system. And because their books were just in terrible shape and whatnot. And the Parla City Council wanted to contract with another water utility because they didn't want their little water company going into receivership, Central Arkansas Water. And so they, had this little secret, agreement with this other water company, and that was not discussed in public. It was not voted on in public. And, the judge said, no, that agreement is void ab initio because it was held in violation of the FOIA. And then they attempted to re-ratify the agreement by, voting for it in public, and said, no, they can't even do that because the contract had been void since its inception. There was nothing there to ratify. It was a nullity, void ab initio. So it can have some serious ramifications, and judges who know what they're doing and know the FOIA, they're not playing. So just saying. Okay, what about emails? And, we'll kind of throw this in with, social media interactions such as text messages or, Facebook or Twitter DMs, things of that nature. The FOIA's open meetings provisions do apply to email exchanges amongst the members. However, it's always going to be a question of fact. Here again, fact specific as to whether or not a series of email communications violate FOIA. And the Wade case is, the case where they discuss that. I have my own opinions about the Wade case. We're not going to go into that right now, but that's kind of the deal with that, is that emails, the FOIA can apply to email conversations or text message conversations. That there's some back and forth, and if there's contemporaneous type exchanges, then that could be found to violate the open meetings portion. Whether a series of emails or text messages or DMs constitute a meeting will depend on the facts of each case. And like it says here, these questions are usually very fact dependent. So they don't often lead themselves to easy yes or no answers. So you have to look at all the facts and circumstances. One thing that I can say, however, is that if there's a series of email exchanges and, maybe the contemporaneous aspect of them, the back and forth, in real time, isn't happening to the point where they're not necessarily in meetings. There's no, that interaction between council members isn't happening. May not be a violation of the open meetings portion, but you can pretty much bet your bottom dollar that those email exchanges are going to be public records that can be requested under the Freedom of Information Act. And oh my goodness, might that be embarrassing if you're having, these kinds of exchanges outside of the public's hearing, even if a court says, well, you know, strictly speaking, it's really not a meeting, but you're not following necessarily the do right rule. You know, the public can get a hold of those email exchanges, even if they're using private email servers. So, you know, you may be having those email or DM messages, text messaging, whatever, and you know, it may not necessarily be interactive because somebody sends it on one day and then, you know, it's missing the immediacy, such that there doesn't appear to be a conversation going on, but you can believe that those records will ultimately be public records. So again, don't do that. Don't let them do that. All right. So we've now decided, okay, the meeting is covered. So what if the meeting is covered? Attendance, the public has to be able to attend the meetings. They have to be able to, at the very least, hear and perceive what's going on. They don't necessarily have to be able to participate, except there is that one statute in the county code that requires county boards to afford citizens a reasonable opportunity to participate prior to a final decision on a given matter. But that's only for county entities. School boards, city councils, other boards and commissions have to permit attendance, but not necessarily participation. Now, participation is always typically a good thing. Can get out of hand, but it's typically a good thing to allow participation. But at the end of the day, the public has to be able to see or otherwise be able to know how each individual member of the board voted. So even if it's, you know, you're having a meeting by telephone conference call, it's important that the public be able to know how each individual member voted. So it wouldn't be sufficient to just take the yays and nays. You know, all in favor say aye, aye. All opposed, no, and then somebody pops in no. You would, in a situation like that, if people can't see the members voting, then you would have to you'd have to do a roll call so that the public would know how each individual member voted. And that also, you know, works with like, and I don't know why a board or commission would do this, but sometimes they might do it by voting slips. And, you know, question is, do they have to keep these voting slips? Well, yes, they do. And they need to be, you know, signed or otherwise marked by each individual member so that the public can know how each individual member voted. That's frightfully important. And meetings must now be recorded. I think, you know, most people are pretty used to this by now because the statute's now almost 3 years old. Act 1098 of 2019, 1028 of 2019, excuse me, requires that all meetings of public bodies be recorded in a manner that at least captures the sound of the meeting. So preferably audio, visual, but it has to at least record the sound. And that's a brand new subsection under section 106. It's subsection D. The recordings have to be kept for at least 1 year and kept in a format that will allow for its reproduction. So, you know, if you've got the sound recording and you've recorded it digitally, it needs to be in a format such as an MP3, or some kind of format that will allow for its reproduction. It can't be in some sort of proprietary format that maybe your city's bought this, special kind of recording equipment, and it makes audio recordings in this, in some kind of format that I've never heard of that's proprietary to this particular manufacturer, and it can't be reduced to, an MP3 or a WAV file or something like that, then that would not be permissible, because you couldn't give out the software. You got a contract for the software, and if the software says, oh no, the sound is only captured in our special, unique, and proprietary format, then that's not going to work. It has to be able to be reproduced upon a citizen's request. And the recording requirements do not apply to some exemptions we're going to go over, or at least one type of exemption we're going over: executive sessions and the meetings of volunteer fire departments. And I've been to a meeting of a volunteer fire department, and maybe they talk about top secret security stuff. I don't know, but I always thought that was kind of strange. Meetings of volunteer fire departments. Okay, sure, why not? Perhaps the volunteer fire departments have a good lobby. I don't know. So let's talk about meetings exemptions. In our case, we're talking about executive sessions. Now, under subsection D, there are under 106, under section 106, there are a number of exemptions, but the only one that we're really particularly interested in are executive sessions. There are other types of exemptions, such as state licensing boards that are putting together, licensing exams and things like that, or a General Assembly's super secret committee of child maltreatment. I think it's the Child Maltreatment Investigative Oversight Committee. I think that's what it's called. Anyway, those other types of meetings are exempt, but those are specific ones. We're talking about executive sessions, which pretty much apply to any governing body. Executive sessions, and these are the types of meetings that you can have behind closed doors without the public, are only allowed for the purpose of considering the hiring, firing, appointing, promoting, demoting, disciplining, or resigning of a public employee. Look at that, I got it right. Hiring, firing, appointing, promoting, demoting, disciplining, or resigning of a public employee. So, you can go into executive session if you want to hire a police chief and you want to, say, interview the police chief. We'll get into that in a little bit. Or you want to, discuss maybe the disciplining of the police chief. What have you. You can do that in executive session, and those are exempt from the open meetings portion of the FOIA. The procedure for going into executive session, you have to announce the specific purpose before going in. There's a question I'll get to in just a minute, so hold on to that thought. You have to announce a specific purpose for going in. We are now going into a closed session to discuss the, disciplining of the fire chief, or the possible promotion of the head of our public works department, something like that. You have to announce a specific purpose before going in. Now, who may attend All right, well, some people can attend by right. There are some people who can attend by invitation, and then there's everybody else. Now, who can attend by right? The governing body members. They have the absolute right to be in that executive session. And the governing body, can't go into executive session and exclude one or more of their fellow members. Like they were trying to, some sort of, dirty backstage deal, trying to exclude members that they don't think are going to be friendly to their particular position. That doesn't work. Those governing body members have an absolute right, even if you don't like them. So they have the right to attend. Who may attend by invitation? The employee who's being discussed about can be invited. They don't have a right to attend, but they can be invited by the governing body. The department's top administrator can be invited. He doesn't have a right to be there. The employee's immediate supervisor can be invited, or an interviewee for a top administrative position. So, like you're going to interview somebody to run your public works department. You can do that interview in executive session, and you can invite that interviewee back in. Who else is excluded? Everybody who's not on that list. And that means, yes, attorneys. If you've got an employee you're going to discipline, or, if you've got an entity that has its own attorney, or the governing body's own attorney, the city attorney, county attorney, what have you, they have to just sit outside with the rest of the public. They are not allowed in, not even if the governing body wants them in. So the governing body can be there by right. Those other people listed there can be in by invitation only, and everybody else is excluded. And I mentioned this earlier, but it bears repeating. Members must come out and vote in public afterward. If they're making a decision in executive session, like they want to hire somebody that they've just interviewed, then they have to come out and vote in public. They can't just hire somebody and say, okay, you're hired. Or let's say, even better example is, let's say they fire the fire chief. And they do that in secret in the executive session, and they come out and say, okay, executive session's over and meeting is adjourned. Well, is that fire chief fired? If he shows up the next day for work, he's eligible to go to work, because the members of the governing body did not come out and vote in public to fire the fire chief after their executive session. So just because they did it in private, it is void ab initio. So it says, who is speaking? The question, who is speaking, is like, who are you? Well, I'm Ray Pierce. I am I'm an assistant attorney general at the attorney general's office. I thought I announced myself before, but maybe I didn't. Anyway, this is me. Another question is, does the AG's office have an example FOIA form that are available to citizens? All right, well, no. The quick answer to that is no. We don't have an example FOIA form, because there is no there's no set rules or format by which a citizen can make a FOIA request. Simply walking up to the custodian and saying, I would like to see this record, please, or I would like to attend this meeting, please. That's a FOIA request. Now, when I worked in an agency, I always counseled my agency, to try to get the FOIA request in writing if they could. So we would have a record of it. But there's nothing in the FOIA that says that a requester has to put it in writing. And there's no magic language, no magic words that have to be used. They don't even have to say under the FOIA, I want to see. It's merely, I want to see this record. I want a copy of this record. Boom, that's FOIA request. So they don't have to cite the statute. They don't have to give you the statute number. Pursuant to Arkansas Freedom of Information Act, Arkansas Code annotated section 2519-101 et sec. No, they don't have to do any of that. They just come and say, I want to see this. Now, if you want to devise your own form, you can do that, but you can't make that, you can't require a citizen to fill out that form or make the giving of records or attending a meeting contingent upon the successful completion of that form. And is a governing body ever required to meet in executive session? For the types of executive sessions that we were talking about, no, they are not required to. Now, like I said, there are other exemptions under Section 106, such as public water utilities. If they're having if they're talking about security of their system, then those meetings are to be held in secret. So there's an example of a meeting that would have to be held in executive session. But that's only if they're discussing security issues. If they're talking about other matters related to the water utility, such as personnel and just general personnel issues, payroll issues, whatever, those have to be done out in the open if it has a governing body. Let's see.
How long to keep?
Oh, yes. I saw that. How long does an agency have to keep personnel files once someone leaves the agency? That would depend on whether if you're a state agency, then the state has a records retention law in Title 25, and I don't know the exact statute number, but there is a state record retention law that would give you an idea of how long those records have to be kept. For other political subdivisions, that's going to depend on if you have a city council ordinance, county ordinance, what have you, but there's not a set time limit where, like the Section 106D, where that says you have to keep those recordings for 1 year. There's nothing in the FOIA that says you have to keep records for X amount of time. Yeah, so FOIA is not a records retention law. And yes, if you to the question, if somebody's asking if they provide some type of verification that the course was completed. Yes, if you would just email, we'll get to that at the very end. So, okay, so now we've gotten to voting in public or the vote or the action is void. That's very good. Okay, enforcement. Now this kind of goes back to what Beth was talking about at the beginning. Enforcing the FOIA. We are not, and I say we, the Attorney General's office, is not a FOIA compliance office. We cannot make anybody do anything with respect to the FOIA. If you're having trouble with, a city clerk who won't give you a particular record, we can't call that city clerk and say, by golly, give them the bloody record. It's covered under the FOIA. That's not what we do. We don't have the authorization to do that. We have no authority. The only people who have the authority to wear black robes, they're judges. And you can either, if you're a citizen and you're getting pushback on a FOIA request, your recourse is to take them to court. Most people just will file a civil suit, file a case in circuit court in the county where they're located, and say, judge, make them comply with the FOIA. There is a portion of the FOIA, there is a statute, section 104, that permits a prosecuting attorney, or it just says that the negligent violation of the FOIA is a Class C misdemeanor. So you could take that to the prosecuting attorney and say, I want charges filed against this person. They're negligently violating the FOIA Act. In fact, I know for a fact that they are willfully violating the FOIA. Depending on how busy your local prosecutor is, may not take up that kind of case. It's only a Class C misdemeanor, the lowest kind of misdemeanor we have. So civil suits are most likely the way most people go about enforcing it. But it is the judge, not the attorney general, that can make somebody comply with a FOIA. Other than that, you need to talk to your local counsel if you're on the side, if you're on the other side, if you're receiving a FOIA request. Talk to your local counsel. How do we comply, or do we need to comply in this area? It is to be hoped that after this and maybe some independent study, you will know on your own whether or not whether or not compliance is required. So. Here again, like I said, negligent violations of Class C misdemeanor, civil judicial enforcement, attorney's fees. Now, this was a new law that was passed last session, regular session 2021. The law used to be that you get attorney's fees if you, as a complaining citizen, had substantially prevailed in your lawsuit to get the public entity to comply with the FOIA. And there had to be a judge's order that, it was, that the public entity was out of compliance, and that, yes, they need to comply by doing, providing whatever records or allowing whatever meetings to be public that you're complaining about. But so you had to go through the entire process to get to a judge's order before you could ask for attorney's fees. Now you can get attorney's fees if, by filing the lawsuit, and then the public agency relents and says, "Oh, okay, here's the records," or "Okay, we'll let you in, we'll make these meetings open." But you never get to a final order. Now you can seek your attorney's fees and costs just for having had to file the suit to make the public entity comply. So that's kind of a new stick, that the General Assembly has decided to do, sort of Damocles, if you will, to hold over public entities' heads to make them comply with the FOIA. So there is that aspect. And here are guides to interpretation. Again, the Freedom of Information Handbook, the 19th edition. We've got lots of them. Please ask, just send an email to us and we will send you just, as many as you want. The 2022 version should be coming out very soon. There's also the Horn book for you law nerds out there, the Arkansas Freedom of Information Act. It's a big, thick book with no pictures, and it's incredibly interesting reading. And then there's our website. You can go to our website. All of our opinions are on our website, and it's an easily searchable engine. And there you go. So, want to say, I'm going to skip those because we're running out of time. So I want to say gracias, thank you, merci, grazie, arigato, spasiba. Thank you very much. For participants wanting to receive CLE credit, for all the attorneys out there, print the CLE certificate that was emailed to you. The CLE certificates need to be mailed back to Rachel Ellis, and I'll just spell that, RACHEL.ELLIS at Arkansas AG. Arkansas is all spelled out, arkansasag.gov. Please email those certificates back within 7 days. And you can use that same email address if you want the CLE certificate sent to you. And if you want some type of verification that you have actually sat through this entire thing, also use that email address to rachel.ellis at arkansasag.gov. And I'm sure she can provide you with something. The CLEST course number for this event is, are you ready? Pound 22/475. Again, that's pound 22/475. And you can email rachel.ellis at arkansasag.gov if you would like our office to submit your name for CLEST credit. It's RACHEL, only one A in Rachel. .ELLIS, rachel.ellis at arkansasag.gov. And that is going to do it for this winter edition of the Freedom of Information Act, made somewhat simple. I hope it was. And everybody enjoy the rest of your afternoon, and good day to you.